Hello everyone, thank you for watching this video. In today's video, we will be looking at one of the requirements for a valid will, and that is intention. Please stay tuned to the next slide as we get into this topic. Let us now look at a quick illustration before going into each requirement for a valid will in turn. Do you have a valid will before you? If the answer is yes, then these three things must be considered. 1. Did the testator have mental capacity at the time of making the will? Did the testator have the intention to make a will? And were the formalities satisfied? Do you have a valid will before you? If the answer is no, then the rules of intestacy will apply. A will is a document that sets out how a person wants his or her property to be distributed upon death. According to Section 9 of the Wills Act 1837, there are three requirements for a will to be valid: mental capacity, intention, and formalities. We will now look at each of these requirements in turn. Intention. The testator must have testamentary intention, knowledge, and approval. The general rule is that testator must intend to make a will. The testator must have a specific intention as well: knowledge and approval of the gifts in the will to be distributed upon death. That is, specific intention is where the testator must know and approve the contents of the will, normally at the date of execution. It is presumed that if the testator had mental capacity and signed the will, they also had knowledge and approval of the will. This can, however, be rebutted. It is presumed that if the testator had capacity, along with signing the will and executing the will properly, there is a presumption of intention. However, this presumption can be rebutted in any of these circumstances. If the testator made a will as a result of force, fear, fraud, or undue influence. Please note that the burden of proving contrary lies with the person claiming the allegation, that is, that there are no intention because one of these circumstances exists. Undue influence. Where someone is contesting the will for undue influence, the testator must have made the will voluntarily and without pressure from anyone else. It must be proven that there has been actual undue influence. This is very difficult to prove compared to proving a lack of mental capacity. Please note that the burden of proof is on the person making the allegation. Let us continue with intention. Intention is presumed where a person had the capacity and the will was executed properly. However, there are situations where knowledge and approval presumption can be rebutted, and these are if the testator was blind, deaf, illiterate, or if someone signed the will, or there were suspicious circumstances at the time of making the will. It must be noted that if any of these circumstances arise, there are no presumption of intention. Let us recap now. According to Section 9 of the Wills Act, it outlines the conditions for a valid will, and intention is one of the conditions for a valid will. We have went through intention, and you must remember that if mental capacity plus the testator signed the will properly, there would be presumed intention. However, this presumption can always be rebutted, and the burden of proof is on the person challenging the will. Also, please note that this is an examinable topic, to make sure that you are clear on intention, the validity of a will. We have come to the end of another exciting video. Please continue to like, share and subscribe for more videos.